Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada but didn't. Today we're talking about murder confessions. Cases that should have gone to the Supreme Court of Canada but didn't. Mr. Gauthier was convicted of murder, and the most important piece of evidence in his murder trial was the fact that he had called his doctor and left a message on his doctor's answering machine, effectively confessing to the crime. The Crown obtained a copy of this message and relied on it for the purposes of proving the case against him. And this case raises very important issues. People have a reasonable expectation of privacy in communications with their doctor. And as the Supreme Court of Canada has recognized in many other cases, communications that are exchanged between individuals don't just require consent from the receiver to be adduced into evidence. They also require consent or an authorization to obtain this information as against the sender. Both the sender and the receiver of messages, including voicemail messages or answering machine messages, should have their expectation of privacy recognized. And that goes doubly so when it is a message to somebody that you have this kind of trust-based relationship where you expect confidentiality. And while it is true that the duty of confidentiality that a doctor has is different than that of a lawyer, where a lawyer would never be permitted to turn their client's murder confession over to the police, the doctor can do that. But that still engages this question of whether or not the state action in taking that message and relying on it when it was clear that the accused didn't intend for that to be turned over to the police is permissible. There are so many layers here between the patient confidentiality layer, the layer of your reasonable expectation of privacy in a voicemail that might be heard by other people, and the confessions rule. These are all important issues that the court could have gotten into and assessed, and a particularly unique factual context, but one that can guide decision makers across the country for admitting messages in two-way type communications. This is becoming an ever prevalent issue in our courts as we resort more and more, instead of to traditional phone call and face-to-face conversation, but instead to digital communication that goes two ways. It's becoming more and more important for judges to have a good framework for determining the admissibility of various pieces of evidence. And unfortunately, the Supreme Court of Canada missed an opportunity to really clarify that and to make some clear, bright line rules about this type of evidence. Hopefully the Supreme Court of Canada does this again, because these are the types of evidentiary issues our lower courts are struggling with across this country and will continue to struggle with until we have those rules in place. Cases that should have gone to the Supreme Court of Canada but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bulk Creative for putting together these videos. Please like, subscribe, and share with your friends.